Major breaking news out of San Francisco. The United States Court of Appeals for the Ninth Circuit, the loony left, out there on the left coast, has issued an en banc ruling concluding that magazines, meaning large capacity magazines, standard capacity magazines that hold more than a certain number of rounds, bans on them are indeed constitutional under the Second Amendment. This is an absurd ruling, but we expected nothing less or nothing more from the majority in the U.S. Court of Appeals for the Ninth Circuit. But let's break down this opinion. Let me discuss the essence of their opinion, why it's goofy, and where the case is going to go next, which obviously will be to the U.S. Supreme Court. Let's talk about it. Hey folks, I'm Mark Smith, host of the 4-Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the 2025 winner of the top voice of the Second Amendment at the Gundies Awards. Thank you so much for your support. All right, let's cut to the chase. The U.S. Court of Appeals for the Ninth Circuit out of San Francisco decided that California's ban on magazines that hold more than a certain number of rounds is somehow constitutional under the Second Amendment. This is another one of these cases, of course, where you have the Ninth Circuit en banc ruling, doing whatever they can to bend over backwards to throw Second Amendment supporters, to throw gun owners under the bus, because there is little doubt in my mind that when it comes to the right to keep and bear arms, there are judges in America that want you disarmed because you are a peon, you're a peasant, you're a subject. You cannot be trusted with arms because you're simply not good enough. So that is clearly sort of the underlying tone throughout the majority opinion as I see it. You're just not as good as government employees who get to carry guns and get to protect themselves with government taxpayer-funded guns. But let's break down the analysis. As you know, this was not a shock. It took a long time for this case of Duncan versus Bonta to come out. We knew the answer, which is, of course, that the Ninth Circuit was going to throw the Second Amendment under the bus, which is exactly what happened here. There were some very powerful dissents in this case, including a videotape, at least in part dissent, not all videotape. It was a written dissent by Judge Lawrence Van Dyke, who also, of course, videotaped part of it. We've covered this before. We'll cover some more of this in a little bit. Very powerful dissent, pointing out, in essence, that the majority of the judges on the Ninth Circuit have no idea how guns work. And that is not a shock because, as we've talked about on this channel, in my experience dealing with elite lawyers and elite judges, even if they're good on the Second Amendment, even if they're good on guns, if you want to say, many of them literally have no idea anything about guns whatsoever. They could not tell you the difference between an automatic firearm and a semi-automatic pistol or any of this stuff except at the most rudimentary level. And Judge Van Dyke, in his dissent with a video on YouTube, which we've talked about on this channel before already, did a great job kind of breaking down the ignorance of firearm technology, which is kind of important if you're going to decide a Second Amendment case. Nevertheless, let's move on and talk about the majority opinion and why it's so fatally flawed. I count no fewer than like 11 major mistakes. There's a lot more than that, but we only have so much video here that you're going to want to sit through. So I'm just going to hit the top 11 screw-ups by the majority, which these are not screw-ups. These are on purpose. These are on purpose to make sure you out there in California and you in America simply don't have the right to keep and bear arms. These are not mistakes. These are, in my view, intentionally designed to ignore Supreme Court precedent in the text of the Second Amendment. That is the reality here. So let's just start from the primary holding. The majority in Duncan versus Bonta of the Ninth Circuit specifically said that as long as a firearm functions as intended, which means goes bang, bang when you pull the trigger, as long as it functions as intended without a large capacity magazine, which, as you know, is really just a standard capacity magazine, those magazines are not arms. Remember what the controversy is. The text of the Second Amendment reads, "The right of the people to keep and bear arms shall not be infringed." The question is whether or not a magazine that is inserted into a firearm is an arm that is protected under the text of the right of the people to keep and bear arms shall not be infringed. And the anti-gunners are arguing that somehow these magazines are not arms, they're accessories or accoutrements, which really should not get them very far, but that is what they're trying to argue. And of course, anti-gun courts like the Ninth Circuit, majority at least, embrace this kind of hooey in ruling against our rights. But let's get focused on this. So basically they're saying that large capacity magazines or these magazines are simply accessories and they're not protected because accessories are not protected by the text of the Second Amendment, only protected arms. And because magazines are not arms, they're not protected. Then they go on to say kind of an alternative theory that says even if you want to assume for the sake of argument that magazines are accessories that can be protected by the text of the Second Amendment, in this case, they're still not protected because California has demonstrated that these magazines that hold more than a certain number of rounds are especially dangerous uses of the weapons, which again speaks entirely to interest balancing, to tiers of scrutiny, which, as you know from multiple Supreme Court precedents, including Rahimi, Bruin, and Hiller, interest balancing tiers of scrutiny weighing the good and the bad of guns and the good and the bad gun uses are all verboten. You're not allowed to get into that sort of analysis. And by the way, you knew the Ninth Circuit was going to go off the rails here in addition to knowing the judges. When you look at the opening line of the opinion, talks about mass shootings. This is fundamentally flawed from the start, because what have I talked to you about before? You understand that when you are assessing, evaluating, interpreting constitutional rights, you focus on the lawful legal uses and the lawful legal exercise of the right. You don't ask, how can this right be abused in some kind of way when you're assessing the scope of the right? Anything can be abused, and that's what the Supreme Court has repeatedly said in Second Amendment cases, which is you focus on the lawful conduct of law-abiding Americans. You don't ask yourself, how can someone misuse a firearm? Because again, anyone can criminally misuse literally anything. Even the most innocuous objects can be misused in some way. So California tries to argue this interest balancing, and the Ninth Circuit agrees with it. They say, well, these magazines are especially dangerous, and we're just talking about a way to use the firearm, but the reality is you're literally regulating and banning a type of weapon, which, as we've talked about before, is a firearm that's capable of firing more than, let's say, 10 rounds. So this is entirely a ban on an entire category of firearm, because you have banned firearms that are capable of firing more than 10 rounds. If you have banned magazines that can hold more than 10 rounds, right? If you ban magazines that hold more than 10 rounds, you have banned all firearms in that state that are capable of firing more than 4 rounds, for example. Now let's go on. The majority also goes on to try, and this is crazy, okay? I'm just going to put this into context, just how absurd this ruling is and this rationale is by the majority of the Ninth Circuit judges. They go on to basically say that the word arms in the text of the Second Amendment, the right of the people to keep and bear arms shall not be infringed. They basically argue that the word arms is a restriction, is a limitation on the right. Did you hear what I just said? Rather than doing what you always do when you're dealing with constitutional rights and interpret the right relatively broadly, they actually argue that the text of the Second Amendment is a restriction. It's not a right, it's a restriction on what kind of arms you can own and can use. Specifically, for example, if you think about it in the context of the First Amendment, which deals with the right to free speech, you have the right to free speech under the First Amendment. And what it says is Congress shall not, prohibit or ban, cannot stop or ban, whatever you want to say, free speech or the freedom of the press, right? It cannot be abridged and so on. Okay, here's the point, though, that it talks about speech and the press textually in the First Amendment. But nevertheless, we in America and the courts in America have never, ever, ever limited the right of free speech and the right of the free press under the First Amendment to simply pure speech and press. For example, we know that handwritten expressions are protected under the First Amendment. We know that writings are protected in the First Amendment, even though that's not speech. We know that paintings are protected. We know that, for example, nude dancing, I believe, is protected. Pornography is protected. All these things are protected speech and or press, even though they're not actually necessarily verbally speaking out loud, for example, or engaging in publishing something as part of a newspaper. So the point being that when you're interpreting other aspects of the Bill of Rights, including the First Amendment, you do it broadly, and not only do you protect the actual thing that's articulated expressly, in this case arms, you also deal with, for example, concomitant rights or ancillary rights. So again, dancing is not speech, but the Supreme Court has repeatedly said that things like dancing or artistic expression or painting, these are indeed speech activities and are protected. So by extension, obviously, magazines would be protected under the right of the people to keep and bear arms in the same way. You broadly encompass these definitions in the Bill of Rights. You don't look to shrink them, but the Ninth Circuit, in defining the word arms in the Second Amendment, literally argues that there's an implicit restriction on one's right there. So the Ninth Circuit is basically saying there's an implicit restriction on the scope of the Second Amendment right, which is inconsistent with how they do it with all other aspects of the Bill of Rights. But let's go on. Then the next major mistake they make is they try to say that magazines are protected to the extent they're an integral part, to the extent they're an essential part of the functioning of a firearm. Then they go on to say, though, that because a firearm will go bang bang, meaning it will function as a firearm, if you have a smaller magazine than a larger magazine, the larger magazines are not protected. Now, this is absurd for many reasons. To begin with, there is no limiting principle. A limiting principle means, okay, so where's a judge going to draw the line? Once you say that the state of California can limit the number of rounds in a magazine, what's the right number? And how do you think about it and figure it out constitutionally? Is it 10 rounds in a magazine? Is it 20 rounds in the magazine? Is it 7 rounds in the magazine? Or is it simply 1 round? Because if you think about it, if your theory is as long as there's a magazine that is in the gun that makes it go bang bang, you could have a magazine that carries a single shot. So you could have a single shot firearm would be protected under the Second Amendment and nothing else. That is simply, of course, absurd. But let's go on to see what else they have to say about this. Remember, all of this flies in the face of that critical language in Newsom'S versus Bruin in 2022, which specifically says that any instrument that facilitates, which means helps, any instrument that facilitates armed self-defense is protected under the Second Amendment. Now remember, they use the word instrument. They don't use the word weapon or arm or gun or anything. It's broader than that. So obviously a magazine that holds more than 10 rounds is an instrument by definition. It's an object, it's a thing, it's an instrument, and obviously it facilitates armed self-defense. It helps people in self-defense situations because nobody ever said, I wish I had fewer rounds in a gunfight. You always want to have more rounds because you never know how many rounds you're going to need. And the fact that police officers all carry what would be considered large capacity magazines, whether they're carrying rifles or handguns, really proves the point that these magazines do indeed protect, again, facilitate armed self-defense. And as we know from Heller, the decision maker under the Heller precedent as to who decides what is appropriate for self-defense is not some bureaucrat in Washington, D.C. or Gavin Newsom in California. It's we, the people, which is why the Supreme Court in Heller says that for whatever the reason, Americans overwhelmingly choose handguns for the purposes of self-defense. And we, the Supreme Court, are not going to second guess this, nor are we allowed to, because they're in common use by Americans for lawful purposes. That's good enough for protection. That's what Heller said. But let's go on and talk specifically about another absurd argument by the majority. Believe it or not, folks, you're not going to even you're going to be shocked by this. But if you look at page 29 of the opinion, the majority opinion basically says that yes, indeed, listen carefully, yes, indeed, it would be perfectly fine for the government to ban, ready, holsters. You heard me right. Then on page 29 of this opinion, the majority of the Ninth Circuit says it would be perfectly fine for the government to be able to ban holsters under the rationale that are articulated in this case. That obviously is absurd because, again, if you look at the Bruin language, it's an instrument that facilitates armed self-defense. A holster helps you carry an armed firearm and helps you facilitate armed self-defense because you can grab the gun out of the holster and shoot it, which is why every single police officer carries a handgun in a holster. Hello, this is a no-brainer. But of course, when you're dealing with the Ninth Circuit, well, maybe brain power. I don't think this is an issue where the judges on the Ninth Circuit and the majority are dumb. I think they're very smart and sophisticated. They just hate you. They think you're a peon. They think you're a peasant. They don't think you have the right to keep and bear arms because you're not good enough, right? You're a subject. You're a serf. Maybe you're even a slave, but you're certainly not smart enough to take care of yourself and your family. You're beneath them. So now let's move on to the historical part. Now remember, the way it works under Bruin and Heller is when the text is satisfied, modern-day gun control law is implicated by the text of the Second Amendment. The burden shifts to the government to show there's some sort of historical-based exception. The example I like to give is you have a right to keep and bear arms, yes, but that doesn't extend to the right to commit cold-blooded murder. But how do we know that? The answer is, if you look at the time of the founding, cold-blooded murder was illegal in all of the states at the time of the founding. That clearly was understood to be that the right to have guns for self-defense did not include the right to commit cold-blooded murder. But the way we figure that out is not from the text of the Second Amendment. It's from looking at history to see there is indeed an exception for using a firearm to commit cold-blooded murder. So you are looking to historical examples to see, is there some sort of exception here that would justify a limitation on magazine capacity? And the answer is clearly not. Now, the anti-gun majority in the Ninth Circuit identified three types of laws. They said, first of all, there are gunpowder storage laws at the time of the founding, which is simply just goes to show you how unserious these people are as judges, because the Heller case has already decided in the arms ban context that gunpowder storage laws are not germane to the question of the Second Amendment, because that was dealing with trying to prevent the city from burning down if you had too much black powder, because it's very flammable. And Boston, for example, was built of really paper and wood. So if you had a big fire, you could burn the entire city. This is not about crime. This is not about gun safety. This was about fire safety, and totally irrelevant, which is what the Supreme Court said in Heller. Then the majority here talks about trap gun laws. But again, trap guns are, I'm worried about somebody breaking into my home, so I set a trap where the gun goes off. Now, the use of guns in this way has long in the Anglosphere and English law been considered illegal, because the problem is, if you set a trap gun in your home, you don't know who's going to walk through the door. And it could be, somebody coming to help your family in an emergency situation. It could be an innocent bystander. There's all sorts of innocent reasons why someone could walk into a home and get shot by the gun. So the gun, here's the thing, the gun is not illegal. You cannot ban the gun. These laws did not ban guns. All they did is ban a particular use of guns and said you can't set up trap guns because it's too dangerous, because you can't discriminate who's walking through and going to get shot by the trap gun. And that's why a long-standing historical law says you can't do it, but that has nothing to do with a banning of a type of gun or a magazine or anything of the like. It's dealing with the use of a gun and not the instrument or not the object itself. And last but not least, of course, they laser focus on how criminals misuse guns. But as you know, in the Second Amendment jurisprudence, the focus is on how people lawfully use guns, not how they can be misused, because anything can be misused, including the right to free speech. All sorts of ways you can misuse the right to free speech, but we don't restrict the right to free speech by virtue of the fact that someone somewhere could abuse it and hurt somebody using their language. So the only other mistake I want to flag by the Ninth Circuit is they basically say that the in common use test, which is very good for the Second Amendment, is part of the textual analysis, meaning they shift the burden to the Second Amendment proponents to show that an arm is in common use to make it protected. That is totally 100% wrong. All you need to do is you look at the text of the Second Amendment, you look at the Supreme Court precedent that has defined arm as anything that can be used offensively or defensively using 18th century laws. That's what was already done in 18th century dictionaries. And then once you realize that something is a protected arm, the burden shifts to the government to do an analysis. And if an arm is in common use by Americans for lawful purposes, it cannot be banned because it is not dangerous and unusual. It fails to meet the dangerous and unusual test, which is what the Supreme Court in Heller said could theoretically be a basis for banning a weapon if it's dangerous and unusual. But remember, where did that come from? That came from the Supreme Court's analysis of English and American history, including William Blackstone. In the Heller case, they were doing a historical analysis. The in common use test is part of that dangerous and unusual historical analysis. And the reason why that's important is because you're dealing with the historical analysis part, you're dealing with trying to figure out if there's a historical exception to the textual right to keep and bear arms. Why is that so important? It's because once you're dealing with the historical analysis part of text first and the history second, the burden of proof is on the government to show that their modern day regulation is constitutional. And because it's on the government to bear the burden of the showing that something is not in common use and thus is dangerous and unusual, that means that the historical part is being undertaken by the government. And who bears the burden to show the historical exception? The government does. But in the Ninth Circuit, according to this Duncan versus Bonta case, they've elevated this up and said that the in common use test, which is really a historical test for an exception to the textual right to keep and bear arms, they elevated up to the text to claim that the in common use test is part of the textual analysis where the burden of proof they claim is on the Second Amendment supporter and not on the government. But that's clearly wrong because, again, the in common use test and the dangerous and unusual test and all this sort of stuff all is derived from history as a potential exception to the textual right. And thus, because it's history, the burden of proof is on the government and not on the Second Amendment proponent. This is commonly errors by judges who hate guns all the time make the same common mistake, but it's totally wrong. The burden of proof is on the government to show historical exception, which means the burden of proof is on the government to show that an arm, like a magazine here, is not in common use and is by extension dangerous and unusual and so on and so on. But the bottom line is, where is this Duncan versus Bonta case going to go? The reality is this. They will probably seek cert. The case will probably sit on the shelf. And what we can hope and pray is this, that the Snope case is granted cert by the U.S. Supreme Court, and then the Duncan versus Bonta case will be held by the U.S. Supreme Court while they decide next term the Snope case out of Maryland, which is the assault weapon, or I should say the assault weapon / AR-15 semi-automatic rifle case out of Maryland. So what we really want is the Supreme Court to grant cert in Snope, put on abeyance both the Duncan versus Bonta case and the Ocean State Tactical Magazine case out of Rhode Island. That is exactly what we want. We need the Supreme Court to grant cert in Snope, and I'm hoping that the Supreme Court knows very well about this Duncan versus Bonta decision. I'm pretty sure they do, and this is going to push them in the right direction, either issue a per curiam decision in favor of the Second Amendment or to grant cert to hear the Snope case next term. That is the likely thing. So again, if I were representing Duncan versus Bonta and the lawyers there, I would probably seek cert. But the reality is I'm really cheering for a cert grant in Snope. That's really what you need because if they won't take the Snope case, I don't think they're going to be taking the Duncan versus Bonta case. So all of our chips are really on the Snope case is my guess. We either going to rise or fall with that decision of whether or not the Supreme Court grants cert in that. All right, there you go, folks. Hope you enjoyed today's show. Make sure you follow me on X at @4boxdiner. Don't forget to subscribe both on YouTube and Rumble, and I look forward to talking to all of you again very, very soon here at the 4 Box and Diner.
Orders up. Table 2A.